Hi guys, and welcome to Credit Makes Sense with Netiva, the Frugal CrediTnista. I'm the owner of M&H Credit Solutions, a financial services firm out of Chicago, Illinois, where credit transformations happen. I'm a certified credit counselor, personal finance coach with a master's concentrated in finance. I want to thank you guys for the overwhelming support I received on the first video that I did on how to properly handle collection calls. And I got some questions from you guys, and I mentioned that I would kind of post them in subsequent videos. So this one is going to go over the Dunning letter, which is usually the first communication that we see from a collection agency, in which they send us a letter about the debt and what we owe and who they got the debt from and all of that good stuff. So we're going to go over that letter. And if you get this letter, do not throw it away. You want to keep this letter because there are some violations that can occur in this letter, and they can get you the upper hand on either getting a removal or getting the upper hand as far as negotiations in case. Because if it's like a large debt, they're not going to remove it for a violation. The violation only is like $1,000, and if you owe like $50,000, you can forget it. But one thing about collection agencies is that they are a business, and business is all about growth and profit. So if there are violations, a lot of them that rack up at the CFP, the Consumer Financial Protection Bureau, the Federal Trade Commission, the Attorney General's office, the Better Business Bureau, that hurts business. And so they would rather give you some type of start some type of negotiations with you than to allow all of that negativity affect their bottom line. So it's a good thing to look at the letter. Don't throw it away. Don't give them the wrong address in case they do call you beforehand, or if you do request it after the fact, because a lot of info can be within there that you can use against them later on. So I'm going to be looking to the side a little bit because I have some notes here. I want to make sure that I give them to you, and I also have some case law. In case you want to do some investigation of your own, which I strongly advise. Never just take what somebody is telling you. Go ahead and do your own research on your own. So the letter should include the amounts of the debt and who they purchased the debt from, or who they're representing if they were just hired to collect on the original creditor's behalf. Now with the amounts, it should be totally understandable. There should be no confusion. Actually, that's a case law, Bartlett versus Heibel. So it says, even though the statute, Fair Debt Collection Practices Act, does not in so many words state that the disclosures required must be made in a non-confusing sense. However, all the courts have pretty much stated that the debt collector may not defeat the purpose of our right to dispute the debt and know all of this pertinent information by making the required disclosures in a form that would make the unsophisticated debtor confused. So yes, I paraphrase that. That's Bartlett, B-A-R-T-L-E-T-T, versus Heibel, H-E-I-B-L-E, from 1997, for those of you who like to do your research. I got some of you guys on here. So pretty much any communication that we receive from a debt collector should be so clear that the most gullible person to the most super intelligent person should be able to read it and totally understand it and not be confused. So that's the first objective of the debt collector when they send you this Dunning letter, this written communication. So the Dunning letter should have the amount of the debt, again. That's understandable. It should have the name of the creditor who they bought it from or who you still owe and they're just hired from it. It should have a statement that unless you, the consumer, within 30 days after receipt dispute the debt, they're going to consider it valid. It should have a statement that if we notify them that we dispute the debt, then they have to get that information that we're requesting to us. It should have a statement that upon the written request within the 30 days, that the debt collector will provide you with the name and address of the original creditor. And if you're writing your validation letter, you should be requesting that anyway, right? So it also requires us to know the entire information that's going to be collected. Now, in the cases where we have, mostly credit cards will give the debt collectors permission to continuously add interest onto the debt. It should state that, like look at the contract or per the terms of your agreement or something like that, or per your state laws, usury laws, because some states limit the amount of interest they can continue to collect on there. Some disallow it, period. So definitely know your state laws. So it should have that verbiage to let them know, or let us know as consumers, yes, this is what the amount is now, but based on the contractual agreement that you agreed to, this is how much can be added on, or please refer to it because this name may not be the full amount if you fail to pay this by X date, something like that. Now, the fail to pay by dates, that's important because our 30-day right to dispute the debt and request validation, that's our right. That's our 30-day right. So they can't do anything that overshadows, and it's literally called overshadowing if you want to research it, overshadowing of the debt. They can't put anything in the letter that overshadows our right to dispute the debt. So if you see a letter that says, immediately pay us now, quick, within 10 days, or it's bold letters, because what happens with these big, bold, or all capital letters, that's what the unsophisticated consumer is going to be drawn to, right? This is case law as well, so let me get you guys that one. This is Miller versus Payco General. So huge, bright, bolded, capitalized letters. That's a no-no. That cannot be in that letter because our eyes are going to be drawn from that. So the unsophisticated consumer will do what? Oh my gosh, let me hurry up and call them. Even the words like urgent, immediate, quickly. No, they cannot put that in that letter. And another one is about how conspicuous this should be. This should not be something that's hidden in small print, that's off to the side. Everything else is bolded, and this is like regular font, 10 font or something. No, this has to be noticeable. So let me give you guys a case law on that. In Chauncey versus the JDR Recovery Corp, the Seventh Circuit has held that demands for immediate or urgent payment overshadow and contradict it says section 692, which is our right to dispute the debt within that 30-day period, unless a full explanation of the relationship between the demand and the debtor's validation right. So pretty much that urgent, immediately, right away, no. Anything that says if we don't receive the amount in full within 30 days, then, XYZ is going to happen. No. So their demand for payment cannot run along the same time that our right to dispute is, because that's 30 days, right? So you can't say if you don't do this within 30 days, but oh yeah, you have a right to dispute the debt within 30 days. That's contradictory, right? So they can't do that as well. So if your letter has that in it, guess what? It's a violation. It's a violation. Let me go to another one. The above account has been placed with our firm for payment in full. Call our office immediately upon receipt of this letter. And then it'll say somewhere else, you have a right to dispute this debt within 30 days. How are you going to tell somebody to call you immediately and then tell them they have 30 days to dispute the debt? So that's a no-no as well. CPLAC versus IMBS. Any language suggesting that action within 30 days is necessary may create a problem with our right to dispute of the Fair Debt Collection Practices Act. Confusing statements such as, if the above does not apply to you, we shall expect payment or arrangement for payment within 10 days from the date of this letter. There's two things there. Number one is confusing. How do you know if your right to dispute doesn't apply to you? It always can apply to you. You always have a right to dispute. Number three, they demanded payment within 10 days. They can demand payment in 10 days if we have 30 days to dispute the debt, because it's not considered valid until those 30 days have passed. That's why it usually takes them about usually about 45 to 60 days to report it to the credit bureaus in the first place. Please be advised that we have been authorized to pursue collection activity, committed to whatever efforts are necessary and proper to effect collection. So any request to the consumer's telephone or anything in writing where if we fail to pay anything or anything like that, that can create a problem. So there's one more I wanted to bring out for you guys. So let me look that one up rather quickly. And let's see here. Okay, here we go. Swanson versus Southern Aragon Credit Services, and that's 1988. Pretty much summed it up really well. The validation notice may not either overshadow or contradict by other language or material in the original or subsequent collection letters sent within 30 days after receipt of the first one. This happens a lot. So you'll get this validation letter, or you'll get this dunning letter, and it'll tell you to you have your right to dispute this. Let's say everything is legit on the first one, and then they follow up with another letter that pretty much says, give us our money now. No, you can't. They call it the 30-day safe harbor zone. You can't tell somebody to, they have 30 days and then start harassing them with letters or phone calls right after that. So this is your safe harbor zone. That's why I say you want that letter. You want that safe harbor zone. It allows you to collect your thoughts, collect your plan of action, get your own documents together to see if this debt is really valid, to plan what you're going to include in your validation letter, because you're not just going to look at the Fair Debt Collection Practices Act. You're going to look at your state laws as well. For instance, Boston has some phenomenal additions to what a debt collector must provide in order to validate or be able to collect on a debt. What's considered validation? They have some great validation. Massachusetts, I'm sorry, I said Boston. So Massachusetts. Texas also has some very favorable collection laws. New York has some pretty decent ones as well, especially on paid collections or credit reporting. So definitely look at your state collection laws in order to find out additional things that you should add in your letter. So a lot of people just get the standard one off of the internet, which is fine. You can definitely do that. But if your state laws require additional things and you're not taking advantage of that, you're selling yourself short. Like, for instance, I'm in Illinois. So if you're in the Chicago area, then debt collectors are required to be licensed and bonded in both Chicago and Illinois. So those are two areas that they have to in order to be able to collect from you. So you want to request it. I want proof. I want proof of your licensure. I want proof of your bonding. So the next video is going to go over what you can ask for in your validation letter. Now, it's not cut and dry, I'll be honest with you. Just like it said that the Section 692 doesn't really go over what's considered confusing or proper language. Validation doesn't do that either in the Fair Debt Collection Practices Act. It gives like a general rundown, but it doesn't go into specifics, which is why we have opinion letters, which can be found on the FTC website, where people have written in, whether consumers, companies, attorneys, for further explanation on the Fair Debt Collection Practice Act and even the Fair Credit Reporting Act as well. So we get a lot of information there for those of us in the financial coaching, and credit repair, credit coaching industry. That's where we get a lot of backup information from. Some of them even include case laws, especially if you can get on a attorney blog or like a credit board or debtor board or something like that. They have some backup laws that are pretty awesome for the regular consumer to go ahead and start researching. So hopefully this was helpful. If you have any questions, definitely let me know. I can be reached at info@mnhcreditsolutions.com, info@mnhcreditsolutions.com. And if you have not signed up for my free Credit Repair Basics e-seminar, please do so. It can be found at creditfrugality.com. Again, creditfrugality.com. And it's just the basics. So I just briefly go over what credit is, the credit repair industry, the consumer laws that govern our industry, and our consumer laws, meaning our consumer laws. And it kind of goes over how to formulate your disputes and things like that. So it's just basic information that a lot of people do not know when they're starting to repair their credit and get their finances situated. So typically people just start pulling letters off of the internet and don't even know what they mean. So this will at least let you know what to look for, what those laws that are quoted within the letters mean, and how to utilize them in order to make sure that your credit report is 100% accurate, 100% complete, 100% verifiable, and 100% timely, which means that nothing is past federal reporting time. So all right. Again, if you have any questions, give me a call, info@mnhcreditsolutions.com. Thank you so much, guys. Bye-bye.